Okay, good evening, everyone. So glad you're here to join us. My name is Christine Paransa-Hagurski. I'm an associate attorney here at the Matus Law Group. And we're here today to talk about how to avoid probate. This is like one of my favorite topics because I'm really not crazy about the probate process. It's so costly, it's so time consuming. It's not something that I really want to share with the rest of the world. I'd rather keep things private. So we're going to be talking about how we can avoid that today. So this is one thing I actually work on a lot here at the Matus Law Group. I do a lot of probate matters. And I always find ways, and by doing this, I find ways to share with people how they don't have to do this for their own estate. Because obviously I'm doing it for somebody else who's handling a probate matter, whether it's for their parents, for their cousins, for their friends, whatever the case might be. And I find ways that I could say, listen, this is for you. This is what you can do. And that's why I'm doing the seminar today, because I wanted to share that with more people. So anyhow, just wanted to share a little bit about me. I'm licensed to practice in New York and New Jersey, but most of my probate matters have been in New Jersey, but I'm starting to work on some New York matters as well. So God forbid, in case you need anything from New York, I'm available for that as well, learning that process. So anyhow, compared to states like New York or Florida, probate is really not so scary here in New Jersey. I know it sounds weird, right? Because everybody's like trying to avoid probate, but it's a little bit more straightforward. However, even if it's straightforward, it's a process. There's still a lot of steps in the process. And there's also a lot of liability for the person who's in charge. The person is called the executor or the administrator. And because sometimes they don't have the guidance of an attorney, there could be a lot of missteps, and the missteps cost the estate money. So to start off, let's talk about probate itself. Why is it necessary? Okay. Let's see. So, okay. What is probate? So probate is necessary when there's a person who passes away with an estate. So an estate means that there were some assets in that person's name. It could be a house, it could be a car, it could be a bank account, a boat, anything. And somebody has to be appointed by the court to be in charge of distributing those assets that was owned by that person who passed away. And that person who's in charge now of the estate is supposed to be responsible for distributing how those assets are supposed to be distributed based on the person who passed away, what their intentions were in a will, or if there was no will, it goes by what the law says. Okay. So the executor of the deceased has like I said, if there's a will, it's called an executor. If there is no will, it's called an administrator. And once that executor or administrator is appointed, they have a duty now. It's a responsibility, not just to distribute the asset, but to keep the court apprised of what's going on with the estate. And in a way, that executor becomes accountable for all the things that happens in that estate. Many people don't realize this, but because of the way, how lax it is a bit in New Jersey, that doesn't necessarily mean that you can just do whatever you want. You still have to follow what the will says. And there are a number of requirements that are required, that are dictated by the court as to how that estate should be administered and how that estate should be closed. And if the executor doesn't follow those specific rules, there's a very good possibility that that executor could be liable even if the estate was technically closed years later. So let's talk about why you should care about avoiding probate. First, money. The probate process might look simple, but there are a lot of hidden costs that many people are not aware of. There are court costs relating to the probating of the will, costs with providing notices to the court, filing fees for the accounting, filing of the refunding bonds. And if you don't have a will, you have to obtain renunciations from the next of kin if you need it. If you can't find a beneficiary, you have to publish it. And often, and this is recommended, but this is a necessary evil, the executor should hire an attorney to help them preparing all of these documents that have to be filed with the court. That's a good amount of legal fees. So there's always another second reason why you should avoid probate. It's time. Even if you submit the will for probate as soon as the person passes away, the court can't act on anything for at least 10 days after the person passed away. You should also wait 9 months after the person passed before you can distribute the estate asset, because there may be creditors that come out of the woodwork and they have until 9 months after the person passed to file a claim. What's worse is if somebody files a caveat. What's a caveat? A caveat is when somebody files something in the court against the estate, which effectively stops the probate process until those claims by that person who filed the caveat are resolved. Who can file a caveat? Well, it could be anyone, but typically it's somebody who doesn't want the executor to be appointed, or somebody who's contesting the will, or a creditor who's owed a lot of money and wants to make sure that somebody who's, a third party is appointed to ensure that the debts that are owed to that creditor are properly addressed. And when that caveat is filed, this often results in litigation, which again means a lot of legal fees and a lot of time before anybody receives anything. Last reason to avoid probate is privacy. Well, the will, the notices to the court, the refunding bonds, which show how much each beneficiary receives, these are all public records. So when a beneficiary receives something at the end, it becomes public knowledge. Why do we want to avoid wasting money, wasting time, and disclosing all the assets, the details of the estate for the world to see? You can see why. I mean, these are the reasons why many people want to avoid probate. So how do you do that? Well, first, let's talk about joint accounts. If you want someone to receive your account outright when you pass away, why not consider a joint account? Usually that happens with husband and wife, spouses. So upon the passing of one owner, that account automatically, by operation of law, as we like to call it, goes to the other person who's named on the account. Of course, this comes with issues, right? If you have a joint account with someone other than your spouse, or a child or a parent, there might be an inheritance tax due. But generally, joint accounts are a way to pass on assets without having to go through the process of probate. A second way to avoid probate is with beneficiary designation forms. Now, these forms are typically used for retirement accounts like IRAs or 401ks or thrift savings plans. Pensions, they're used for life insurance policies, they're used with annuities. Basically, each one of these financial institutions, they'll tell you who are your beneficiaries. You fill out a form with the financial institution, you name a beneficiary, or maybe multiple beneficiaries. You can even name contingent beneficiaries in case somebody in the first line passes away. So if you have an account that allows you to name a beneficiary, consider using this as a way to pass on your assets without having to go through probate. A third way of avoiding probate is a pay on death account. Did you know that you can name somebody as a beneficiary of your checking or savings account without giving them access to it while you're alive? So you see, joint accounts give someone access to the account during your lifetime. That was number one, right? But if you only want them to receive that right to access that account upon your passing, consider a pay on death designation. So if you want to pass that on without having to worry about that person having any kind of credit issues and a creditor coming to seize that account because technically they're owner of the account during their lifetime, or if you just want to name somebody else to receive that, not have to worry about probate, pay on death on your checking, on your savings is an option. The fourth way to avoid probate is to gift assets during your lifetime. Okay, I know, admittedly, this is not the most popular way to transfer assets because we want to be able to use our assets during our lifetime, right? We want to be able to still have some measure of control over like how much money we have, go on vacation when we want to go on vacation. But keep in mind, to avoid probate, once you transfer assets to someone else, even if it's at your deathbed, that asset will not be part of your probate estate. This is a very difficult approach if you are considering qualifying for long-term care through the state, through a program called Medicaid. Medicaid is a program wherein individuals who need long-term care, like a nursing home or somebody coming to their home to take care of them because they can no longer do certain things every day. So they need like a nurse or a home health aide. Medicaid will pay for certain things for you, pretty much to take care of you. But you have to be very careful about giving away assets during your lifetime when you're trying to qualify for Medicaid. So if you have enough assets and you're just giving things that you just want to be able to, pare down, it's okay to give. But if you're concerned about possibly needing long-term care down the road and you are in this gifting plan, talk to an elder care attorney before you do that, because we have to make sure you don't run afoul of those rules from Medicaid. So, and lastly, one of the cornerstones in a state plan that avoids probate is to create a revocable living trust. I like to think of the revocable living trust as a toolbox. Very, very wise person told me that one time. You create a trust. So a trust is really, it starts with a document that says who the owners of the trust are, who's in charge, the trustees, and who the beneficiaries are of that trust. It talks about who the money is going to go to after the person who owns it passes away. It could be in trust for minor children. It could be in trust for a child with special needs or a family member with special needs. It could be going on for generations in a dynasty trust. There are so many ways that you can craft a trust. But why is this going to avoid probate? Well, so what happens here is when you create a trust, you also have to fund it. Funding means you transfer accounts. Instead of being in your name, it's named in the name of the trust. So it could be a house, it could be an investment account, it could be bank accounts. And you can also name the trust as beneficiaries of your IRA, like I was talking about before, your IRA, life insurance, 401k. And what happens after you pass away, because you no longer own it, it's owned by the trust, you avoid having to go to court to request an executor to be appointed to manage it. Because in your trust itself, you already have a person who is going to be in charge after you pass away. So that's why the court doesn't have to appoint an executor. That's why the probate process doesn't have to happen. That's a way of avoiding trust. And it doesn't have to be a lot of assets. I gotta tell you, I have people who are establishing trusts. They don't have millions and millions of dollars, but they want their money to be spent a certain way. They want to make sure that they're protecting their assets in a certain way after they pass away. In a way, want to kind of reach out to whoever you pass on your assets to and still have a measure of control even after you pass, because the trust document really tells those beneficiaries what their rights are. So, talking about how revocable trusts work, keep in mind, an irrevocable trust is not something that you just create yourself. I would really recommend you talk to an estate planning attorney to do that. It is not a very difficult process, but it could be a lengthy process depending on how many assets that you put in there. However, the work that you do to fund the revocable trust in the beginning kind of outweighs all the work, down the road in the end after you pass away, because if everything's in the trust, it's so much easier for your family to be able to access your assets after you pass without having to go through that lengthy probate process. So, next slide. So those are the 5 ways that you can avoid probate. I mean, probate, like I said, it's not a terrible process, but it's tedious, it's time consuming, it's costly. And if it's something that you can avoid, there are ways around it, whether you have a large estate or a small estate. You could just have one bank account. Why go through probate if you just have one bank account, There are also ways of titling assets, like I was saying, joint accounts, even for houses, life estates, where you're a life and beneficiary. But the way you title assets makes a difference, and the way you have beneficiary forms makes a difference. It's really important to talk about those kind of details when you're looking at your plan altogether. I always like to look at it as, what do we have now? What's going to happen if I pass away? Let's make sure it goes to the right people in the way that I want it to go, to go to them. So that's why it's important to really talk to somebody about how those things are going to come to pass. If it were to happen now, or maybe 5, 10, 20 years from now. So anyhow, I see that there are questions. You would check. Okay. First question is, how long is the probate process? Well, if we know we've addressed all the debts of the estate, it could be very quick. But because creditors can file claims against the estate for at least 9 months, for the first 9 months after somebody passes away, I would always recommend at least 9 months. And you know what? It's not just that 9 months. It could be even longer. And very often it could drag on even longer than that, years, possibly, depending on what the assets of the estate are. And second question, is probate the same for every state? No. So each state has its own rules. Some are simpler than others. Jersey, like I said, pretty simple, but still pretty tedious. Some states like New York or Florida, wow, I'll be honest with you, a lawyer just has to get involved with the amount of filings that you have to do with the court to prove who's the executor, how the executor is supposed to distribute assets, all the court filings that go along with that. It could be a very lengthy process. Just getting the executor appointed in the state of New York, you need to have consent of all the beneficiaries, which is, sometimes that's 2-3 months, depending on how you can reach them. So before you can even be appointed as executor, it could be a lengthy process in New York. In New Jersey, all you need to do is submit the will to court along with a death certificate, fill out a form, and that's pretty easy. If an estate is really small, is the next question. If an estate is really small, do you still have to probate? Well, technically, you still have to file something with the county surrogate court. So basically, who's in charge of your estate when you pass away? First, you have to go to the court in the county where the person resides. Fill out some paperwork, and if you don't have a lot of assets, in that estate, it all depends on who's receiving it. And if it's under a certain amount of money, and depending on what you state to the court as the assets of the estate, it could go through a very simple process. But still, the court gets involved even with the small estates. There may be less work if it's a very small estate. There may be some, a lot less paperwork to be filed, but you still have to get the court involved no matter what. All right. So I see there's also a question in the Q&A section. Give me 1 second. So we have here's the question. We have an investment and retirement accounts, and we own our condo. If we designate beneficiaries for all of our accounts, but do not make a revocable trust, will only our condo go to probate? So technically, yes. It depends too on how the condo is titled. So if it's 2 of you who are on the title of the condo, and only one of you passes away, it doesn't go to probate yet because the surviving owner receives that asset outright. But upon that surviving owner's passing, it does go to probate. So I have a question here too about long-term care insurance policy. Let's see. Can I still do any of the 5 steps? Let's talk about that. So you can absolutely do that with a long-term care insurance policy. Well, basically, a long-term care insurance policy is ensuring that if you do need some type of long-term care down the road, your policy pays for either 100%, 75, 70%, some percentage of all of those of that care. And that care could be really expensive, right? It could be anywhere from $5,000 to $8,000 for somebody coming into the house and providing you with the care, or even up to $15,000, and I've even seen $35,000, depending on the kind of care that you need in a nursing home. The long-term care really is a different type of policy. You can have a long-term care policy that turns into a life insurance policy if you don't use it, but you can have a long-term care policy that only provides long-term care. And it could be, if it's a joint one, your spouse could be using it if you don't use it. But all those other steps are really for your other assets, like your investment accounts, if you have any, your bank accounts, your life insurance policies. So yes, you can still use those steps, still have a long-term care policy, and still avoid all of that, all the costs of probate. Okay. I am under the impression, here's a question. Thank you, buddy. I'm under the impression that a beneficiary designation takes precedence over the will. Please comment. Absolutely. So a beneficiary form is something that you fill out, like I mentioned before, in step number 2, where you fill out beneficiary designation form. If you put a person or a trust as the beneficiary of a specific account, that person or that trust will be receiving the proceeds of that particular account. And if your will says, oh, this account that I have with Merrill Lynch, I want that to go to my husband, but at Merrill Lynch, you make your first husband the beneficiary of that account, it goes to your first husband. Because the beneficiary forms or the POD or the or the joint account overrides that will. So that's one thing that you have to be very careful about when you're making this plan. You have to know where everything goes. And your will doesn't override certain things. It certainly does not override beneficiary forms. It doesn't ride PODs. It doesn't ride joint accounts. And it certainly doesn't override your trust if you have one. Is that a good answer, buddy? All right, let me see. Are there other questions that I can? Okay, 1 second, I have a couple more. Is there a reading of the will? So when you have a will, right, you see that on TV a lot. There's a reading of the will after somebody passes away. It's not required. So nothing in New Jersey law really requires the reading of the will. However, one thing that's part of the probate process is if a will is probated, meaning it's submitted to the court along with the person's death certificate, and a person is being appointed as the executor of that will, that executor has a duty to notify all the beneficiaries under the will and the next of kin of the person who passed away that person has been appointed executor. And now the appointment is, it could be a letter saying, by the way, I've been named as executor. It could be as simple as that. Or I've been named as executor, here's a copy of the will. But there is no need to have a reading of the will. Is it good to have a reading of the will? Sure. Is it helpful? Maybe. It really depends on the family dynamics. But no, there is no requirement under the law. Hopefully that answers that question. All right, I've got another question. Can you put some sort of beneficiary designation pay on death on a deed? Well, actually, that's interesting that you asked that question. It's not exactly called the beneficiary designation on a deed. It's called a life estate. So say, for example, parents passing on assets to children. We had this very recently, in fact. So you have a life estate, which means for my lifetime, I'm going to own this house. But upon my passing, I want it to go to my child. I could be I could be the owner during my lifetime, but upon my passing, there is a residual, I like to say the residual of the asset goes to my child. Keep in mind when you do that, the child now also has an ownership interest. So if you ever change your mind and you don't want that child to receive that house anymore because, I don't know, made some bad choices during their lifetime, you can't just undo that easily. You have to have permission from that owner too. So naming a beneficiary in a deed, that's one way of doing it, having a life estate and then passing it on after your lifetime to whoever the actual owner is now. Or you can have joint ownership. Joint ownership means both of you are actually 100% owners. I know it's hard to envision two people having, 100% ownership, but that's what joint ownership means. You both have ownership of that asset during your lifetime, or you can be something called co-tenants, where each of you own 50%. So yes, it can be done. Those are 3 ways that you can definitely do that. Any more questions? All right. If there are any more questions, I'd love to hear from you. One thing that we do offer all our clients that are here, well, prospective clients who are here today, is a free peace of mind session. So that means we'd love to talk to you. We'd love to just talk about what your concerns are. If you have a will, maybe you'd like us to look it over and make sure that everything that you want in your life now is still, going to happen if this will were probated. And it could be too that you'd like to just think about other things that you could do with your estate plan. Make sure you provide for other beneficiaries. Maybe now you have grandchildren. You want to make sure your grandchildren receive some of your money instead of just your children. Maybe you want to split things up a different way. Or maybe you want to talk about somebody else who might be a better person to take care of you in case you're no longer able to take care of yourself through a power of attorney. We'd love to just hear from you. We'd love to talk about what works best for you now to make sure that you have the peace of mind that you deserve and making sure that something happens to you now, you're taking care. So we're offering a free peace of mind consult. It's an hour meeting. We can do it by Zoom. We can do it over the phone. We can do it in person, either in our Toms River office, our Red Bank office, and maybe even our New York office. Up to you where you'd like to meet. So we'd really like to meet with you, create a very unique plan that works for you. And hopefully, this can build a lasting relationship with us, because we're here always to make sure that your life is always in good order. And when things happen, we're always happy to help you, your family, and making sure that everything's in place for you. So here's our contact information, 732-281-0060. You can book online if you can put up your QR code to our screen, or you can just call our office, send an email to our admin. And we look forward to hearing from you, and hopefully we'll see you soon. Thanks so much for joining us. That was fast.